Hello friends, we have finally made it to the third part of our three-part series regarding what factors a court here in Florida will consider when establishing a parenting plan and corresponding time-sharing schedule. We're going to go over the last 8 factors that a court will consider, including the catch-all provision. So welcome back to the Divorce Broadcast. My name is Manny Segarra, coming to you from Miami, Florida. Alright, so jumping right into our analysis of the factors of Florida Statute 61.13, we're going to talk about domestic violence. Yes, the next factor. Evidence of domestic violence, sexual violence, child abuse, child abandonment, or child neglect, or evidence that a parent has had reasonable cause to believe that he or she or the child or children are in imminent danger of becoming victims of domestic violence, regardless of whether a prior or pending action relating to these issues has been brought. It sounds complicated, but in a nutshell, what it means, there are some enumerated offenses, which means cases involving domestic violence, sexual violence, child abuse, child neglect. If in a particular divorce case there are allegations of that type of behavior, the court will consider it. Also, we did a video on the modification of the parenting plan statute here in Florida. There doesn't have to be an official case. It has become akin to an injunction in that the parent only has to have a reasonable belief that he, she, or the child are going to be eminently a victim of domestic violence or some sort of abuse. Big stuff here. And then there's additional language that says that if the court is going to accept evidence of any type of prior or pending actions regarding these enumerated offenses, the court must specifically acknowledge in writing what evidence was considered. So it puts an obligation on the court as well. I would be remiss if I didn't remind all of our viewers that we have previously filmed a couple of the domestic violence videos and how they interact with divorce cases. So please make sure that you take a look at those. And in every single one of those videos, we have always posted the domestic violence hotline so that in case anyone is going through some sort of domestic violence, they can call and try to get help. So let's break down what some acts of domestic violence, sexual abuse, or child abuse may be that a court would consider here in Florida. Physical abuse, any type of hitting or slapping, the use of physical force to cause harm or injury. This may include kicking or punching, and some of the more egregious crimes include choking or strangulation. Up next is emotional abuse. Some examples of emotional abuse is constant criticism, belittling or demeaning the other spouse, using derogatory or degrading names against the other spouse and insulting them. Humiliation, deliberately embarrassing the other spouse or shaming them, either in private or in public. Up next may be psychological abuse. This includes different types of behavior, including manipulation, gaslighting, when one spouse purposely denies the reality of the victim's experience, making the victim doubt their own perception of how they see things. Threats, stalking, whether that be constant calling, texting, harassing behavior. Up next is sexual abuse, when a party forces sexual acts, coercing or physically forcing the victim into sexual activity that they don't want to be involved in. And sexual degradation, using sex to either threaten, manipulate, or demean the other party. Another example, which may not be physical but can be just as devastating, is the financial abuse, when one spouse controls the finances and does not let the other spouse know either what's going on. They restrict the victim's access to joint accounts. Sabotaging employment is another great example, when one of the spouses undermines their character so that they can't get a job or that they lose their job. Maybe they try to interfere with their ability to go to work. Exploiting financial dependence, when one spouse may be the bread maker or the one that earns the higher income and the other spouse is the homemaker. Maybe they manipulate how they give money to the spouse that needs their assistance in order to meet their basic needs. Given the rise of social media and technology, another form of domestic violence has arisen, which is technological abuse against the other spouse. This may include the use of monitoring devices, whether they be the car tracking devices or the little Apple devices that you can put on that will track locations. This could mean stealing passwords to monitor computer activity, harassment online, and also revenge porn. A lot of times when a divorce divorce happens, one of the spouses takes intimate photos and starts to use them against the other spouse or to show their family or their friends or maybe even post them online. Additionally, it's very important to speak about how domestic violence affects minor children, especially when they observe a domestic violence incident or incidents can have a profound and long-lasting effect on children. Let's talk about how. First, trauma and stress, higher levels of anxiety. This may lead into depression. Also, behavioral issues. Aggression can be internalized by these children. They may have issues controlling their own anger, or on the opposite spectrum, they may withdraw and isolate as a coping mechanism to address the domestic violence that they witness. Academic and cognitive problems, that's a big one. Additionally, children who witness domestic violence may have trouble forming their own relationships. They may have difficulty trusting others and may exhibit inappropriate amount of attachment issues with their partners as life goes on. There's also a lot of research indicating that children in homes with domestic violence suffer all kinds of physical ailments, which include headaches, stomach aches, and sleep disturbances. Finally, and perhaps one of the worst results of children observing domestic violence is that it may continue the cycle of violence, meaning that these children become at very high risks of repeating the behavior that they observed. It's important to note, however, that each child's response and needs after observing domestic violence is going to be different, and the best form of combating any type of long-term consequences is early intervention and obviously therapy. But having said all that, remember that the courts will be keenly aware and very interested in any issues relating to domestic violence in a particular case. Moving on to the next factor of Florida Statute 61.13, it's a controversial one, and that is whether or not there's evidence that either parent knowingly provided false information to the court regarding any prior or pending action regarding domestic violence, sexual violence, child abuse, child abandonment, or child neglect. So, remember how we did this whole section on how a court will consider domestic violence and if the children observed it? Well, if one of the spouses either makes a false report of domestic violence or it can be proved that the spouse was not forthcoming when they reported domestic violence, a court will be very interested in that as well. And let's try to explain why. Remember, if someone gets arrested for domestic violence or if there's an injunction for protection against domestic violence that's issued in a case, until those two other cases, the criminal case or the domestic violence injunction case, they get sorted out, oftentimes one parent is not allowed to see the children. So if the result of that separation is because one parent lied about domestic violence, a court will really look into that. And I can tell you, courts do not like people lying about domestic violence or providing false information to the court, because a lot of time and effort and a lot of training for law enforcement and the courts and all of the advocates for domestic violence goes into trying to protect people who are legitimately victims of domestic violence. So if someone is trying to game the system, it's not going to go well for them. All right, so when trying to see if allegations of domestic violence may not necessarily either be corroborated by the evidence, perhaps they're false allegations, we've got to look at a lot of different places. So one of the places that I like to look at first is if there's a criminal case and that criminal case was dismissed or the prosecution decided not to move forward with the case, either because the victim either failed to appear or failed to prosecute the case, or maybe there are independent witnesses whose story doesn't corroborate what the victim is saying. That is a big sign. Also, the dismissal of an injunction, because it may provide evidence that they're trying to make statements that aren't corroborated and may not be true. If, however, the injunction is granted, or at least a temporary one is, and then they go to court and have a hearing, if after a hearing a judge determines that the statements weren't true or that the allegations aren't true, then it becomes an even bigger issue, because at that point you have proof that either statements weren't true or there was no corroborating evidence. So those are the first two places I personally like to look at. Up next is the inconsistency of the stories. A lot of times there are contradictions and inconsistencies in the alleged victim's story, what they say in divorce court or when they're testifying, as opposed to what they wrote perhaps on a police report, or maybe what was said on a 911 calls. In addition to that, body cams are now available quite often, and the police officers can actually see the victim, and there's a video of it as the victim is telling their story. So you'll be able to see if there's any injuries. They'll be able to see what the victim's demeanor is on the date of the incident. Also, there may be witness statements that doesn't corroborate their story. Same thing with the lack of evidence, the absence of any type of physical evidence. If the victim or the alleged victim comes and says that they were punched in the eye and they were choked, and then when they pull the police records or any video that might be there, there's no injuries. If the person doesn't look like they were in a fight or an argument, this is all valuable evidence to prove that the charges may not be true. An additional layer is looking to see if there's a history of false reporting, as well as the timing and motivation. If the injunction or the arrest occurs right after someone files for divorce, or let's say the arrest occurs after someone gets time sharing with the children, have to look at it with a critical eye. I'm not saying that automatically it's false, but look at the timing, look at the motivation. All right, so we're up to the next factor, which is going to be the particular parenting tasks customarily performed by each parent and the division of parental responsibility before the institution of the litigation, meaning what were each of the parents doing before they filed for divorce and during the pending litigation, including the extent to which parenting responsibilities were undertaken by third parties. So there's a lot to unpack. The court in this factor will look at what were the parties doing. Was somebody the workhorse for school? Was somebody the parent that always took the kids to school, always fed them, always picked them up, always went to the meetings at school, and the other parent was just kind of coasting, and all of a sudden they file for divorce and the other parent has become super parent and is going everywhere? So courts will look at historically what parents have done, and then if a divorce is filed, courts will look at what is happening during the pending litigation. We have mentioned before that while the case is pending, asking for either time sharing with your children or to be able to have a say in their parenting decisions, you can't just slack. You got to be involved. But what's also interesting about this particular factor is that it contemplates what third parties do. And when they say third parties, they mean grandmas and aunties and uncles. So we're going to talk a little bit about that now. So let's get into some of the parental responsibilities that a court will look at before, during, and as well as what third parties may do. Education. Who's taking the kids to school? Is grandma or a nanny taking the children to school? So courts are very interested in that. Healthcare decisions. Are the parents involved with the doctor's appointments, the dental appointments? Were they there for the immunizations? Were they there for emergencies? Mental health issues. If the child has to go to mental health counseling, are both parents supportive? Are both parents there? The role of third parties. This is a tricky one because I am a big believer that it takes an entire village to raise children. So if the parents get along, it's beautiful that the children get grandma and aunties and uncles and cousins all involved in time sharing. But if the parties don't get along and the children are given to a grandparent while the other parent is available, then the courts will look at that and maybe curtail that. So it's important to see how each case kind of evolves and what the circumstances are of each case. Again, pro tip, don't come to court asking for time sharing if you've never in your life been to a parent-teacher conference, never been to a extracurricular activity, don't know who the children's doctor and dentist is, and aren't involved in the child's life. Because the court's going to be looking at you like, what are you talking about? The very next factor is very similar to the one that we spoke about, and that is the demonstrated capacity and disposition of each parent to participate and be involved in the child's school and extracurricular activities. I'm not part of the Florida legislature. It's curious though that these two factors that we're discussing are so similar, but the legislature made sure to make it a point to say involvement in the children's school and extracurricular activities. So let's break it down. Again, this is a big one. When it comes to school, a parent needs to be there. Make sure if there's an open house, you go to the open house. Make sure if there's a supply list, you get everything on the supplies if you can afford it, and you show your face to the teacher when you hand it over to them. If there's a parent-teacher conference, you gotta go. You can't just show up for the award ceremony. You got to go for the good and for the bad. If there's a meeting with the principal or the guidance counselor, God knows that I've been called into many a meeting with principals. You may not like it, but you have to go. And I suggest you bring some donuts. If there's an IEP plan, if the children have special needs, it is so important for both parents to show up because it sets the tone for the educational plan. When it comes to extracurricular activities, are you taking the children to practice consistently, on time, with the required stuff? Is the parent there in the cheering section when there's games? Get the little spongy hand waving for your kid in the crowd. Does the parent have coaching skills? If they do, put the coaching skills to use. Become the Little League coach or the Girl Scout troop leader. In addition to this, promotion ceremonies. I love the promotion ceremonies. When my son did martial arts when he was younger, the one that everyone thinks about is when the kid chops the board. If they're in karate, if they're in some sort of jiu-jitsu, it's so cute because the little guys or the little girls fight each other or they wrestle each other, and it's so cute to watch them. Is there a dance recital? Is there a instrument recital? Is the parent taking the children to art class? Are they taking them to singing lessons? These are all things that can be easily recorded and registered, the participation of the parents, and they're also important. Now that we've given some examples of how parents can be actively involved in school and extracurricular activities, let's talk about examples of when parents cannot. Sometimes work gets in the way. Parents who have a demanding job or an irregular schedule may not be able to make these meetings. There may be language barriers. If one of the parents, their native language is not English and they can't communicate, they may not feel like comfortable going to these parent-teacher conferences, or maybe they have a limited educational background and they feel a little bit uncomfortable or intimidated to go to these meetings. There may be health issues. If one of the parents has significant health issues and cannot physically go, maybe there's a geographic distance. Maybe one of the parents doesn't live in the same town or the same state as the other parent. Or maybe there's personal issues and stress. I'm a big proponent of therapy, so that parent should try to get those issues resolved. And in a worst case scenario, maybe there's some sort of substance or alcohol abuse issues. So if a parent is not as involved as the other parent, there better be a valid justification, or a court may frown upon that. Up next, a very big factor, the demonstrated capacity and disposition of each parent to maintain an environment for the child or children which is free from substance abuse. Let's give some examples of substance abuse. Let's start with one of the big ones, which is alcohol abuse, which leads into impaired judgment, impaired coordination, and irresponsible behavior. Drug addiction, the use of illicit drugs, including substances such as cocaine, heroin, methamphetamines, and things like that. Opiate use, I know there's a big opiate crisis. The abuse or use of prescription medication inappropriately, such as painkillers or sedatives or stimulants, whether or not they were obtained by a prescription, they use those drugs and they become impaired. Smoking or vaping, the use of tobacco and exposing the children to that. The abuse of marijuana. A lot of states have allowed for marijuana to be legal. A lot of people have medical marijuana cards, but the abuse of it. In addition to this, drugs that cause you to hallucinate, like LSD, shrooms, psychedelics. Those can cause a bad reaction, and if the children are exposed to that, it may make them feel really bad and really scared. So what happens if you get busted or get caught abusing substances? Well, let's start with the obvious one. The court may limit access to your children. The court may also require a parent to have supervised timesharing or supervised visitation, which means that you have to go to a governmental agency and somebody's going to observe that parent having timesharing with their children. And if they have a little bit of money, at least it'll be at a park somewhere or at some other facility like a mall. They'll be able to pay for a supervisor, but not everyone has that type of money. And if they don't, they have to go to a court building, usually downtown, and have time sharing with their kids then. And if that doesn't work, it happens on Zoom. One of the more common sanctions is mandatory drug testing, whether it be the drug testing through a hair follicle test, because in the hair follicle, the drugs stay in the system a little bit longer, or worse yet, the random drug testing. Here in Miami-Dade County, they make you submit to random drug testing for a year, and what happens is you may be on site in the middle of work somewhere, in a very important meeting. They're like, yo, you got a drug test and you got to drop everything you have going on. You have to come downtown and you got to drop pee in a cup to see if you're using drugs. So it's not ideal for someone that needs to be worked. The court may require to use what's called SoberLink. I think that's a great application. You know, people who get DUIs, they have to blow into their car in order for the car to start. With SoberLink, you have to blow into a tube so that it registers what your alcohol content is, and depending upon the agreement or the court order, you may not be able to see your kids. There may be a substance abuse assessment or substance abuse evaluation where the person that is addressing these issues has to meet with somebody and see if they have a substance abuse issue. And if they do, the court may order treatment. And this treatment may be counseling, it could be group therapy, and some people will go into a facility. So these are all the options that the court can consider if someone gets busted using substance abuse. The next factor that the Florida courts will consider under Florida statute 61.13 is also a big one, and that is the capacity and disposition of each parent to protect the child or children from the ongoing litigation, as demonstrated by not discussing the litigation with the children, not sharing documents with the children or electronic media related to the litigation with the children, and to refrain from disparaging comments about the other parent to the child. First, let me tell everybody, judges hate when children are told about the litigation. They really, really, really get upset with that. So that's the first part of it. And the second part of it is not disparaging or talking smack about the other parent. So examples of people who would look bad in the eyes of the court. First, exposing the children to conflict, either through engaging in very heated arguments or time-sharing exchanges with the children present, or discussions about the divorce in front of the children, especially if the case is going to court. Using the children as messengers. That's also a very bad move. Involving the children in communication between the parties about what the ultimate time sharing schedule is going to be or what the child support is going to be. It puts an inappropriate burden on the children and they feel horrible about it. Speaking negatively about the other parent, and it doesn't just have to be verbal. It could be the non-verbal communication because children pick up on that. Using the children as leverage. Maybe one parent wants to say, okay, I'll give you X amount of time sharing or visitation if you give me Y amount of child support. All of that is bad. Undermining the other parent's authority, disregarding another parent's views or punishment, and a lack of boundaries. Now, let's give examples of parents who are doing a good job of shielding the children from the litigation, starting with the parents who avoid discussing all the legal issues or financial matters with the children. They don't talk about the divorce. They just talk about the regular issues that they would talk to their children about. Maintaining a civil relationship with the other parent. Using appropriate communication channels. That's a huge one. You know that on the show we're big fans of the different apps, including Talking Parents and Our Family Wizard, so that the parents can communicate directly with each other and not use the children as messengers. To encourage a healthy and loving relationship with the other parent when they are supportive of that relationship with the other parent and to spend time with them. Parents should be mindful and respectful. They should make the transition or the time-sharing exchanges pleasant, peaceful, and if necessary, finally, if a parent is feeling like they're having trouble with this part, go to therapy. We're huge fans of therapy on the show, and a therapist will help you and provide you with some tools on how to manage that relationship with the other parent so that you don't put the kids in the middle of it, because the courts really don't like that. All right, we're getting to the second to last factor that we're going to talk about today, and we're talking about the developmental stages and needs of the children and the demonstrated capacity and disposition of each parent to meet the child's developmental needs. Remember, children, they grow constantly, they change constantly, and they have various developmental needs that encompass their physical, social, emotional, and their cognitive aspects and lives. So meeting those needs is critical. So let's give you some examples in terms of physical health, nutrition. Obviously, it's important for them to be fed appropriately and get the right meals. Exercise is just as important, and adequate sleep is huge so that they're well rested and they can go to school the next day and concentrate. Up next is emotional well-being, the love and affection from both parents, emotional expression, stability and consistency. It's huge in terms of social skills, peer interactions. Are they involved in the Boy Scouts or the Girl Scouts? Do they have a theater troupe? Anything that allows them to have peer peers. Empathy, it's huge. Can they place themselves in the shoes of other people? Are the parents also creating children that have compassion for other people? In terms of their cognitive development, do they have a stimulating environment or educational opportunities? Are the parents allowing for the children to have autonomy and independence? Are they giving them age-appropriate responsibility? Also, very important is play and creativity. Do the parents allow for the children to have time to play and express their creativity? And finally, spiritual and moral development. Are the parents teaching them values and morals? Are they exposing the children to their culture? These are all things that a court will consider. All right, so we've reached the final factor of Florida Statute 61.13, and that is the catch-all factor. And it says any other factor that is relevant to the determination of a specific parenting plan, including the time-sharing schedule. So the catch-all is there to see in case there's something unique about a child. I'll give the example of maybe one of the children has special needs. Maybe they're on the autism spectrum, or maybe it's an extremely talented kid in a particular sport. So let's say there's a figure skater and they need a special time-sharing schedule. And another one that I always find interesting is what's going on with the blended family. When one of the parties is getting divorced, they may have now a new significant other that also has children. The court may want to know how that spouse's new partner, what their kids are doing, and how they're involved with the kids in this case. So there's a catch-all provision for the court to consider any factor that the court finds to be relevant in this case. And I love it because each child is different and unique, and I think this is a wonderful catch-all provision. All right, so that is a wrap on the third part of our three-part series relating to Florida Statute 61.13, which is the breakdown of all of the different factors that the court will consider when establishing a time-sharing schedule and parenting plan. Woo! That was a lot of info, so I hope that all of you take the time to look at the discussions and see how each factor may be relatable to a particular case. If you know anyone that might find this information interesting or helpful, please have them reach out to us at www.segarralawfirm.com. We have offices in Miami and Orlando, Florida. Se habla español. Do us a favor and like this video. Please subscribe to the Divorce Broadcast. And for those of you that have reviewed this information and have any comments on maybe some of the factors that should be considered by the court, or maybe there's a catch-all example that you may want to give us that we didn't think about, go ahead and give us some comments. In the meantime, wishing you all the very best and thank you.